I just want to say, this podcast idea was my idea.
Ooh.
I've been pushing this thing
He's so right. Yeah.
So clearly you have more pull in the organization than I do.
Already.
Because I've been telling Ben and Bruce to do this for a while now. And so I'm glad we are finally getting it done.
Welcome to Claim Talk. My name is Danielle Young, and I am a senior relationship manager here at ClaimDoc, and I have with me today Omar and Matt, and I will let you guys introduce yourselves.
I am Omar Arif, Senior VP of Growth here at ClaimDoc.
My name is Matt Schwarzkopf. I'm one of the attorneys here at ClaimDoc.
Yeah, we're going to get down some rabbit holes in attorney land for Matt here in a little bit, but we wanted to start the podcast by telling you a little bit about why we're here and the purpose of the podcast. And really, it starts when I first came to ClaimDoc a couple of months ago, recently. I came out here to Des Moines, where the headquarters are. This is where we're filming this and shooting this today. And just kind of got to meet everybody, got to meet Omar for the first time in person. Actually, no, it was the second time, right? Because the first time we met would have been in Indianapolis.
I don't recall.
When you came to our event?
Oh, yeah.
So I met him for the second time.
That's a good start here.
Yeah, it's a good start.
Well, you came to our deal and presented, and I thought she can present better than most of my team.
Oh,
we need her.
Too kind. He's being too kind. Yeah, so we met there in Indy. But anyway, so I came out here, got to see Omar again, and then spent a lot of time just getting to know the other people that work here at ClaimDoc. Something unique about ClaimDoc is that the entire team, with the exception of a handful of sales folks, operates under one roof here in Des Moines. And I thought that was really unique, first and foremost. But second of all, virtually everyone that I met was just really, really smart and has a great deal of passion for the purpose of what we're doing at ClaimDoc and the work that we do every day. And I was really, really taken by it. And so the last day that I was here, I cornered Ben and Bruce in Bruce's office, and I said, I really think that we need to have a podcast so that we can bring the expertise and the passion and the know-all that we have under this one roof out to the market. Because I think it's really important that other people who are potentially partnering with us or recommending us to their clients know exactly how we function and how we operate and what our core values are, because they shine through our people every single day. And so after we had that conversation, we started sort of spinning our yarn around how we were going to do this, and we ultimately landed on Claim Talk, which is the forum we're on now to talk through the things we do and what we do and how we do them, so that our clients and our partners and our friends out in the industry can be more informed about what we do. So all of that being said, what you can expect from us is an episode covering a specific topic and featuring some specific experts that we have internally here at ClaimDoc. We want to get into the weeds a little bit, but we also want to keep it topical and light enough that nobody falls asleep. So we want to be informative and make sure that you get to know and love our people internally as much as I fell in love with them the first time I came here. So with that, what we're going to talk about today is we're going to get a little bit in the weeds on the No Surprises Act. This went into effect as part of the Consolidations Appropriations Act.
There you go.
Got it. Nailed it. In 2020. And so what we wanted to do is kind of get into the weeds around the No Surprises Act, why it's important, and how we interface with the act and what we do for our clients and with our TPA partners is unique and different than maybe what some others are doing in the space. So Omar, tell us a little bit about your background before you came to ClaimDoc.
So I've been in the benefits business this is year 16.
Oh, wow.
So I've worked for a carrier. I've worked for a TPA. ClaimDoc is reference-based pricing stop number 2 for me. Before ClaimDoc, I was at a bigger shop called Imagine 360, who we compete against and everybody in the space knows. So I've been at ClaimDoc for about 3.5 years now, and I just want to say, this podcast idea was my idea.
Ooh.
I've been pushing this thing for
he's so right. Yeah.
So clearly you have more pull in the organization than I do.
Already.
Because I've been telling Ben and Bruce to do this for a while now. And so I'm glad we are finally getting it done.
Yeah.
The second thing I also want everyone to know is Claim Talk was also my idea as well.
Okay.
So
have you gotten it all out?
The podcast is mine. Claim Talk is mine. And yeah, I just wanted to make sure that was out there.
I appreciate the clarification. As does our audience. Yeah.
Yeah. So yeah, 3.5 years now, I manage our sales team and do my own personal production as well, and help out wherever else I'm needed to help.
Yeah. And Omar has been on several podcasts talking about ClaimDoc several times prior to today as well, right?
Yeah, my friend Spencer had me on his show, and he's got one of the more popular insurance
Self-funding with
related,
Spencer.
plug.
Sponsored by ClaimDoc.
And once he had me on, everybody else that had a podcast asked me to come on too.
Sure.
So now I've become like this podcast guy in our little
Seasoned pro.
niche inside of our little niche.
Yeah.
So yeah, it's been fun. It's been a good run, and I'm glad we're hosting one now. So thank you for stepping up and agreeing to be the hostess of the Claim Talk show.
Also, while we're on the record about things, I did not volunteer for this job. I was assigned, and I'm enjoying every minute of it. Matt, tell us about your background before you came here.
Sure. So I've been at ClaimDoc for probably about a year now. Prior to this, I was a trial attorney at an insurance defense firm in Des Moines, Iowa, handling everything from personal injury cases for big insurance companies, trucking cases, malpractice. Decided to do a career change. One of the other attorneys here is a friend of mine from law school. So she just raved about the culture here, the kind of work you guys were doing in the health insurance space, and that it might be kind of interesting to segue over and kind of take the experience in trial work, litigation, different part of the insurance world, but bring it here and see what we could do. And I'm glad you guys are starting out the podcast on a high note with who everyone knows is usually the most charismatic person in the company is somebody from legal.
Yep.
So I could only really go uphill from here. But yeah, so I've been here about a year, still learning a lot. I think I was told it probably takes like 3 years to really kind of understand kind of healthcare, especially within the reference-based pricing niche, and always having to be a student of the product. And that's kind of something I enjoy too, is learning something every day and learning how to apply that to what we do in legal in a functional way that, one, doesn't put people to sleep and is understandable and digestible for clients.
Yeah, 100%. Yeah, so before I came to ClaimDoc, I was on the broker side for 15-ish years. I started in a small family firm, moved to a more mid-sized regional firm, ended up at a large national firm where I was when Omar and I met, and I had been actively selling ClaimDoc as a broker partner, and I've sold RBP for many, many years. Different iterations of it, level funded, fully self-funded, different iterations of the same RBP product I've sold. And over that period of time, over those years, I really started to develop a set of criteria that were sort of must-haves for reference-based pricing to work. And ClaimDoc is the only solution in the market that I could find that truly checked all those boxes in one comprehensive solution without overcomplicating it by adding different parts or offering certain this, that, or the other. It's an all-inclusive solution that just made a lot of sense for my client partners. So when I met Omar and we sort of started kicking around the idea of coming over here, was something that was really easy for me to decide to do because I truly believe in the work that we're doing.
So hold on, I'll stop you there. So I was told not to plug the program on the podcast.
Oh, okay.
So
sorry.
let me ask you this question.
Yeah.
Who is the second best RBP vendor in the space?
By name?
Yeah.
I think it's Imagine 360.
Oh, okay. All right.
Yeah.
Fair enough.
Are you going to divulge that? Oh, did you? I can't remember. Did you already tell the audience that you already that?
I did. Yeah. I just was curious your take on
the second. Yeah, I think that's the second best. And they're also sort of the OG. You know.
They did pioneer the industry. I will give them that.
Yeah.
Sure.
Yeah, and that was the first RBP vendor that we worked with when I was getting involved in reference-based pricing. So let's jump in to Matt's favorite topic over here. And it might not be his favorite topic, but today we're really focusing in on the No Surprises Act and how that works and how we work with it and what we do that's unique and different. So you gave me a really great rundown earlier of the No Surprises Act.
I knew I already blew it.
Yeah. We had the one good round and that was it. Yeah, no. So go back, if you don't mind, and kind of explain to the audience how it came about, when it came about, and what the intention behind it was.
So gather around. It's real earth-shattering stuff. So back in 2020, they passed what we mentioned before, that Consolidated Appropriations Act. So within that act, you really had kind of two different sort of consumer protection ideas. One is the No Surprises Act, NSA, which we're going to talk about today. And the other part of that is, the transparency aspect of it. And what we mean by that is, the machine-readable files that we're getting from providers now, trying to bring that charge master kind of out into the light and tools for the consumer to use to really shop around and understand what's going on. So, and that's an entirely different podcast we can get into. And ClaimDoc itself has tools and is pioneering part of that, and a lot of change in the industry in the past 2 years on how we integrate that with clients and how the industry as a whole is dealing with that as well, and providers too, getting them to comply with the law in a timely way and in a way that we can actually take that pricing information and use it. But for today's topic, the No Surprises Act, what that does is that eliminates surprise billing for really 3 categories of services. So the classic one you're going to have is an emergency service. Say, God forbid, you're driving down the interstate, you get in an accident. That paramedic who comes up to you is going to be like, hey, ma'am, what network are you in? We'll take you to that hospital. They're going to take you to the hospital that's closest to give you that life-saving care, that immediate care. So it used to be, you wouldn't have a choice. You'd go to an out-of-network hospital and you'd be charged for that. Well, it's not exactly fair. You didn't have a choice. So that's really the premier service that when you say NSA, that's an easy example you can give to people. The next common example that happens is you have a covered service by an out-of-network provider at an in-network facility. So a recent example for me for that is my wife and I welcomed our first baby back in November.
Congrats.
Thank you.
Congratulations.
So if I'm a little haggard or fall out of the chairs because I haven't slept. But so anyways, she gives birth at an in-network facility. And sometimes that anesthesiologist that comes in, real important part, you just kind of assume, hey, this person's part of the hospital. And, they obviously are allowed to treat on patients. Not exactly. They just might have rights there. They're not actually within the network. So you get through all that good stuff, you get home, you're settling down, and you get that substantial bill from the anesthesiologist, and you're like, what is this? So that also is another service now that the government has prohibited balance bill on, because you don't know. A person with common sense, and even an educated person, they're not going to know that. You're not really in the mode to agree to that. If you're about to give birth or you're at a in-network facility, you think you've done all the right things. The third service that they prevent surprise billing on now through the law are air ambulance services. So, that image of that helicopter showing up to an accident and getting you out of there. Ground ambulances are not covered. I'm not exactly sure the reason why. I have a couple ideas. We discussed earlier. Could be a lot of those are ran by municipalities, city governments, things like that. So there's some nuance there why it wasn't covered, but you're still going to get that bill for a ground ambulance. But otherwise, those are the 3 main services that when we think of NSA, that's what we're talking about.
Got it. Okay.
So it's emergency services, out-of-network providers at an in-network facility, and then air ambulance.
That's correct.
Okay.
So once we start getting into that, that's the first part. Now it's prevented. And the great part about that is you take the member out of that experience, because in each of these instances, having a child is, it's exciting, but it's also terrifying too. Being in an accident is without a doubt terrifying when you have to get emergency services. Air ambulance is, I've been on helicopters before, they're fun, but I wouldn't want to be on after an accident. So the law is good intended with that, right? So how do you go about now? Because the providers still, they need their money. So if they can't balance bill the patient, what are they supposed to do now? As part of the No Surprises Act, the government came up with kind of a 2-pronged approach on how the provider and the plan can deal with each other. The first part of that prong is this open negotiation process. And how that's initiated is that within 30 days of a service, the plan's got to pay. That's not 30 days after we get all the relevant information or 30 days after a billing error has been fixed. 30-day calendar days, clear stop. We have to either give that initial payment to a provider or a notice of denial.
And then we were talking about this earlier, Matt. 30 days from, it's not the date of the claim, it's 30 days from the date that the
bill is
transmitted. Yep. Okay, cool.
So, and of course, because laws have to be complicated, we're going to jump from 30 calendar days to 30 business days. So once that 30 business, we give the payment and the provider's looking at like, I don't like this. So within 30 business days of receipt of either that initial payment or that denial, they have to come to us and say, hey, we don't like this. We want to negotiate with you. We're going to open up the system through a notice system. It's basically a piece of paper with the codes on there. The data service should have all the identifying information for that claim. And then, hey, we're going to go back and forth and try to negotiate a compromise on this bill, if we want to reach, a middle ground with that. In the event that the open negotiation process doesn't work, and that goes on for 30 business days, either party can then initiate the independent dispute resolution process, the IDR. And the IDR is no more open negotiation, no more back and forth. That's when the payer and the provider each submit their own number, baseball arbitration. Omar, you played baseball. I don't know why they call it
Yeah. Let's pause for a second on this, because we were talking about this earlier. Matt and I were talking about this. Baseball arbitration, Matt was explaining to me, means that there are two rates. The provider and the payer have decided their two rates, and there's no splitting the middle. There's no splitting the difference. It's one or the other. What is that? How does that relate to baseball at all?
It's a similar contract negotiation where an arbiter decides who gets their way, the player or the organization.
Oh, okay.
Oh, there you go.
Makes sense. Yeah. In case you didn't know, if you watched Omar on a podcast before, you should know this, but Omar played a lot of baseball. Semi-professionally? Was it semi-professionally?
Yeah, I played minor league baseball a long time ago. It's embarrassing to talk about. Also,
so we won't talk about it anymore.
Times, yeah.
You can go find another podcast that he's on and get that entire background. Sorry, Matt, go ahead.
Oh, no, good. It's far more interesting than what we're talking about now. So as you can see, like, probably your eyes already rolled in the back of your head, timeline after timeline after timeline. So we go through all of that, and then once we get to the IDR, again, another clever name, it goes in front of the IDRE, or the Independent Dispute Resolution Entity. And within the space of the No Surprises Act sort of claims, I think there's about 10 or 11 organizations that have been certified to do this work. You submit it to one of those 10, each of our numbers, we submit briefs, and then to the letter of the law, it's really supposed to be within 30 days of that certification of that entity. They're supposed to get you a response back, a payment determination, which is binding and absent, fraud or collusion or a pretty high bar within the legal community, that you'd have to be able to bring a claim under. You're kind of tied to it.
So something else I wanted to point out, you said, so there's only 10 entities that can go through the review process. And how many claims have we seen go through this process since the inception of the piece of legislation?
For just claim doc, or for
well, let's say nationally, if you were to hypothesize.
So millions easily.
So we have 10 entities managing millions of claims since the inception of this piece of legislation. And what has happened as a result of that in your professional opinion?
Huge backlog. Again, it's about 10 to 12. I would need to go back and check the numbers. What I can tell you definitely is that last year, the number that was touted by a lot of surveys was that within the first 9 months of the No Surprises Act, it prevented 9 million balance bills. Wow. So you can kind of extrapolate that number into a larger purpose, which again, we're kind of going to beat up on this law a bit today, but there is some good with it, and it's doing a lot of good for the consumer. It's just a lot of fits and starts.
Sure. And
a lot of hiccups that go along with it. But from ClaimDoc's position, we've had probably about 255 since last January of 2023 that have gone through. And we are still waiting on about 155 for determinations.
So we're still waiting on most of them.
2/3 haven't been processed.
So, and again, you're looking at a process that, hey, we'll get you a response 60 days, best bet. And it's been a year.
Who are these entities who are these arbiters that are controlling this process?
I think they generally come from what's called kind of the independent review organizations. I think just generally what you find. So when I think of arbiters from a litigation background, it's entirely different than what this system is. An arbiter is basically kind of a judge, and you see a lot of that in contract cases. Our different trade unions will have their own sort of arbitration system. They want you to abide by their rules for. Again, contract cases are by and large what you see the most of. As to who these 10 are, and I could give you some names. I have to go get my book, but generally just an organization that should be vetted, to handle these claims, been certified by the government to do it. In my experience in litigation is generally the people that did arbitration, they had background in it, and mediators similar to, these were trial attorneys, they were judges. I can't tell you if these, the IDREs here really understand healthcare law. And like we talked about before, Danielle is a trial attorney, dealt with insurance claims all the time, healthcare claims all the time. I never really cared what that bill charge was. The number didn't matter to me because in Iowa, you can never put forth bill charge for evidence. We just cared at the end of the day, what was the paid owed on the insurance? Not ever thinking about these emergency cases of, well, how did this happen? Or, how did they get to this number when that bill charge was that? And that's not, ignorance or anything. It's just these people it's a different sort of insurance, or they have different sort of backgrounds. And again, I've been here for a year and I feel like I've barely even scratched the surface of how general healthcare works. So you're getting these organizations that have to go through millions of claims. You have a provider that's telling you one thing and a payer telling you the other, and you have about 5 factors that you really need to consider, and you have a bunch of prohibited factors that you can't consider. And at the end of the day, I think they're just trying to get through as many of these, as competently as possible to free up the logjam because everybody is upset about it. Providers are upset, payers are upset. It's just not a great system. And real quick, what I told you before, and I really believe this, I think, those review organizations were given a bad break because the IDR, from my perspective, it's a process designed not to work. It's a process designed that it's so unpleasant for you that you will settle in that open negotiation process so you don't have to deal with the IDR, eat the fees, and have this uncertainty with it.
Makes sense. And I would also assume that because this is a federal law, that the appointed entities conducting IDR were appointed by, some federal agency, HHS or...
I was going to ask that, yeah. Are
somebody.
Does the government get involved in deciding who can be an entity, or is it like their government contractors?
I'm not too sure on the background of that. I've never looked into it.
Rabbit hole.
So, again, it's just, we got the backlog of claims and you can kind of fight about it. But at the end of the day, again, barring something crazy happening and fraud or anything like that's incredibly difficult to prove to begin with, there's nothing we can really do to contest these anyways, that we're looking at now. So we focus on the problems that we can deal with. And that's why our bread and butter really is that open negotiation process with these providers. And another thing that we really provide to the client, I think that you get the most value for your buck, is compliance with the TPAs too. Because it's not just us. We have to work hand in hand with our TPA partners to get these claims processed and adjudicated in a timely fashion.
Yeah, I was going to kind of steer us in that direction. I wanted to hear you articulate for our audience, as we spoke earlier, there are certain things that a third-party administrator can do, should do, are legally required to do, but sometimes don't always do on behalf of their clients, and it can create sticking points that are painful for the client. Do you want to explain that?
Yeah, absolutely. So again, as we talked about, these timelines are important. And when that initial explanation of payment, EOP, EOB, EOPs, you guys have too many acronyms for my taste. But
guys, you're in it now.
I know.
Okay, right. You're one of us.
I still like to feel like I'm on the outside. But so when that goes out, part of the law requires, in the comments section at the bottom, it's got to have some magical words. Part of that is the qualified payment amount, which I'm sure people in this space are familiar with. And for those of you who don't know, the QPA, that's just generally the median contracted rate for a same or similar service. So you look at that code, you extrapolate out, given, just say January 2019, what's the median date for that, plus inflation? I think they've upped it to hopefully a sooner date than 2019, but,
Or recent,
our claims department would be happy to come on here and tell you how they do all that. They do a great job with getting that data bank and making sure the QPA is up to date. So that's one of the things on there. A couple other attestations that, hey, we've complied with the law on how we've calculated the QPA from the database, a few other things. The kicker for us, and where we've kind of had the most friction, is that kind of the third prong of that is, hey, provider, if you don't like payment pursuant to the law within, the 30 business days, you need to open up an open negotiation with ClaimDoc, and here's our email, here's our phone number, all that information. What we're finding is that oftentimes TPAs, not all of them, they don't have the magical words on there. And we find that out because providers will balance bill our members. And we reach out to the provider and be like, hey, this is a No Surprises Act claim, it's illegal. Like, well, the explanation of payment didn't have the magical words.
So it's a legal loophole that because the TPA didn't include the language.
It's a pretty lame one, but it's one that they use, and now we're stuck arguing with them about it. And the real kind of concern is that now you have a member who should be taken out of that process, and now they're thrust back into it. And they could be getting collection notices, they could be getting letters, things of that nature that they shouldn't be. So now it's on us to not only kind of deal with that, instead, when we should be dealing with this open negotiation part, now we have to go through and make sure that the TPA is being compliant, because we can't do our job without that. And the other side of that coin is not only does it open up the member to some legal fraud and liability, the plan too can have issues. And what I mean by that is, everything is funneled through emails or a system. So if they don't have our information, the provider, they send it to the TPA. Good TPAs know, like, hey, this is NSA, this goes to ClaimDoc, they handle it right away, it goes to our team. Other times, 2 months will go by and we get an email, be like, does this belong to you guys?
Right.
And, and we're 60, 90 days past. In that point, the provider could have been like, hey, they're not responding. We're going to open up the independent dispute resolution process. Well, guess what email they use for that process? Guess what contact information they use? None, or the TPAs. So we don't get it. We can't show up and advocate on behalf of the plan, which is a serious problem.
So hold on, you're telling me that if I had a large emergency room bill and the TPA didn't put the proper language on my EOP, that I could be, as a member, I could now be held liable for that claim because of some language error on...
If a provider wants to try to take advantage of that, or not even take advantage of it, this is all paper pushing on that end. It's just all revenue. Somebody's clicking a button and not paying attention. Well, after it's sent out and some processes have started, it's hard to pull back, right? You don't want to admit that you're wrong. And there, quite frankly, still is a lot of ignorance on how the law works. And to be fair, the law changes constantly.
Yeah, I want you to tell the story you told me earlier about you were speaking to the head of revenue at a hospital system about this topic. And will you tell that story?
Yeah, sure.
Yeah.
It was Sarah on her team. Her and Brandy are really the workhorses that, do all this wonderful work for the plan. And again, they're just inundated with stuff, but if they get it timely, they can respond to it. And part of what we do is this outreach with providers. Yeah. We're not trying to lay the law down. They're not getting a nasty call from me or a letter. We're like, hey, clearly somebody messed something up here. This is a No Surprises Act. Your qualm is with the plan. It's not with the members. With us at ClaimDoc, we'll work through it and develop, a fair payment solution if you think you're owed more than what we paid for. So anyways, we're talking to a revenue guy and not somebody fresh out of school or this is their first job. Like, hey, man, I just work here and read the prompt. This is, management of the revenue cycle. And he told us that the No Surprises Act only applies to people without insurance.
Wild.
Which it clearly doesn't.
To me. Right. And that's what we were talking about earlier, is that it clearly doesn't, because part of the legislation uses the word network.
Right.
You can't have out-of-network billing if you're uninsured. That's very...
Which, when I came here, I thought I was going to get my hair back from less stress being out of trial work and starting to thin again. But that's, you're up against, again, a well-intended law poorly executed. You're up against compliance issues. You're up against providers that will take advantage of that.
Yep.
So the best that we can do here, and what we pride ourselves on and what we're absolutely willing to do, is help those TPAs with that compliance issue. Right. And, we have great partners that we can have that adult conversation with, because, hey, you don't want this liability either. That's not a good feeling to go to a client like, hey, we lost. Well, why did we lose? Like, well, we didn't even show up.
Right. We didn't put the language on the OP. Yeah.
I'm not going to guarantee we win all the time, but we put forth a good product and a good effort, and we are successful in that open negotiation process. But it's a real bad and uncomfortable feeling to tell someone, now you have this adverse payment determination. And real quick on top of that, it's not even, you think that billed charge is going to be the worst that you'll get out of that. We've seen providers ask for more than billed charge, and they'll get it because the independent dispute organizations that monitor, they're like, hey, that's not our responsibility to double check the math. It's, one number or the other number. We're going to pick the other number. Too bad if it's...
So even though their billed charges are publicly posted, they can still somehow get more than that in a IDR process?
Call it a clerical error, essentially.
Well, there's nothing in the law that prevents you from seeking more, it seems. So even outside of the billed charge, they'll be like, I guess they could say we had to go through this trouble. We're going to ask for as much money as we can. Yeah. And nobody's here to contest that.
Wow.
So
do you have any stats, or if not, just a general feeling on how we save the plan's money in an open negotiation setting versus actually going to IDR? Like, where the outcomes are better for our plans?
A little bit. I don't have the most up-to-date stats, but I did ask our team, hey, the past 20 claims that we've settled in open negotiation, how are we looking? And 85% of those were well below the 300% of Medicare that we strive for. The outliers, what you have to take into consideration too, are they small bill claims that if we go to this dispute resolution,
400%, right. There's such a small amount anyway.
And on top of that too, you have fees that go into that as well.
Right.
And the fee structure changes if it's a single claim or if it's bundled. So now that becomes part of the calculus. That's part of the risk, right? Because not only do you risk getting, the provider who's, why wouldn't they ask for bill charge? Why wouldn't they ask for as much as they can get? So not only do you risk, losing that, on top of that, you have to pay the fees as well. So we look at an open negotiation, run the math and see what's the best outcome for the plan in this situation. And we balance that too with, does this particular review organization, do we have good luck with them? Are they ones that are nuanced in their determinations that really explain, hey, here's why we picked you, or here's why we picked the provider, which nobody likes to lose, but it's good to get that information so we can improve. Or is this one of those organizations that doesn't say anything? There's errors in the determination. They had the names switched up, the numbers aren't right. If I have to go up against that organization, I'm going to want to try to settle in open negotiation. If I know that provider particularly enjoys using that particular review organization, we're going to want to get this settled in open negotiation and not, have to deal with fees, not have to worry about it. And two, a dollar in hand or a determination in hand is better for everyone than having outstanding, 154 outstanding determinations that we're still waiting on a year later. So,
well, I'm a conspiracy theorist, and
fun fact.
And I know that the large health system lobby is a lot more powerful than individual self-funded employers around the country. So, do you see a scenario where IDR becomes more profitable for the big systems down the road?
I'll tell you from our experience, and if you go to the big conferences, they kind of talk about it too. One of the issues with the backlog in IDR is a bunch of claims from providers that don't belong there being shoved in. Out of that 254, we've challenged and won 50 that didn't belong there. Just get them out. These clearly aren't NSA claims. They belong somewhere else, or they haven't used our appeal process. And that's part of it too. That's really the job of the organization that reviews it to do it. But we have to be vigilant too. If we see it, we catch it, we're going to say something about it. Do they always listen? No. But that's a huge issue with providers who have the bandwidth to just shovel stuff into the pipeline. And, on our end, since generally the payer doesn't initiate, we're stuck with just trying to play whack-a-mole, keeping up with the legit claims, and then trying to weed out, the non-legit claims that don't fall under the auspice of the law that don't belong there.
So to go back to Omar's conspiracy theorism, it's possible that just by volume that the large healthcare system, like if they just continue to inundate, that would be how they would possibly manipulate the situation to their benefit, right?
Absolutely. And a lot of the fits and starts too, there's been a series of lawsuits down in Texas. Again, a whole nother podcast conversation with providers not liking the QPA. They don't think it's fair, which is funny because the entire RDR process really is geared towards providers. It's more provider friendly. If you look at the entities that use it the most, it's area ambulance generally, and those guys do shake out pretty well.
Yeah.
I think on that end. But so it's a lot of, CMS and the government stopping. What is this law going to say? What is this judge going to say? How is it going to impact our implementation? So you put a hold again on those determinations. It restarts a month later, try to churn through them, stops again. Yeah. Churn through a bunch, stops again. So, we're constantly checking with guidance from CMS, how are the lawsuits changing? What do we need to do on our end to make sure we're being compliant? But yeah, it's, the dog chasing the car pretty much at this end.
And what happens when you catch the car?
I don't think we want to know.
We don't want to know. Yeah. Well, thank you so much, Matt, for your insight. And this is what I was talking about when I first came to ClaimDoc. What's so exciting is getting to talk to people like Matt who are wildly knowledgeable and articulate and passionate about what we're doing. So we appreciate that. And to summarize, essentially, do you want to take a shot at the summary?
No.
Okay. So I think to summarize, what's really important about what Matt and his team are doing is helping make sure that our TPA partnerships work in conjunction with us and our clients really well to maintain compliance with the No Surprises Act and make sure that, especially because we co-fiduciary with our clients. So that's extremely important to us as an entity as well. As to our clients. So is that a fair, did I do a decent job?
It's not all doom and gloom. Again, it's straight for the consumer. In a large part, again, is, what I often think of before I came to ClaimDoc, or, when my wife had that baby, who's the version of me on her insurance's side if she gets that balance bill on an emergency claim? Does she just call a hotline and hope for the best? Or
maybe,
at ClaimDoc, you have, a legal team, you have people here located within this very business that reach out and call those providers that have a vested interest in making sure that member is taken out of the experience.
Yeah.
And put it back to the plan, because that's what the law says. And let us do our job of advocating on behalf of the plan and protecting the member. And I think that's what we do well with our CPA partners, and again, is constantly retooling, just fidgeting. It's never going to be 100%, but I think we do a pretty good job of keeping up with the upkeep of the engine to make sure it goes.
I think that's
Nice.
fair to say about all things reference-based pricing, right? Like, we can't do it perfectly, but we try really hard every day to get better at it, right? So
I thought you came to ClaimDoc for me.
I'm really sorry to do this on the internet, Omar, but there are other people here that I like too.
I'm kidding.
Thanks. Well, like we said, go ahead and keep your eyes peeled for more interesting knowledge and diving down rabbit holes with our expertise here at ClaimDoc that hopefully helps enlighten you, our friends, our clients, our partners, and provide some context around the work that we do on our reference-based pricing and fair payment solutions here at ClaimDoc. If you enjoyed or learned something new from the content that you heard on Claim Talk today, please like or subscribe wherever you listen, and we look forward to seeing you next time.